Welcome to Looking at Legal Stuff. Today we have 8 hearings, including an evidentiary hearing for custody, with a couple where dad has been given temporary custody of the children and mom has supervised visitation until the outcome of their trial due to a CPS investigation into allegations of abuse by mom's boyfriend and threatening and unstable behavior by mom. Mom claims that all of those allegations are unfounded and dad's lying about everything. She says they had previously agreed that she could have custody of their daughter and dad could keep their son. She says she should get the child simply because she wants her. Dad says that mom has threatened self-harm when she doesn't get her own way, and that she also recently came and took their daughter and is refusing to return her despite the court order. What does the judge think about this mess? Let's find out.
Two cases. Calling case 2020-4060S, Emily Cornell versus Dylan Hall. Calling case 2023-685DM, Dylan Hall versus Emily Hall. Today is Monday, April 24th, 2023 at 9:51 a.m.
Okay, court will note the appearance of Mr. Umlauf on behalf of the defendant and plaintiff respectively in the various cases. The first one the court will address easy is the plaintiff's motion to consolidate. There are 2 actions before the court: a complaint for divorce filed on March 10, 2023, and the pending DC case 20-406. The court will consolidate the cases in this matter so that we're not proceeding on 2 separate actions. The next case is the defendant's motion to establish parenting time schedule. Mr. Umlauf.
Good morning, Your Honor. I'll largely rely upon the motion we initially submitted to establish specific parenting time schedule, as there have been a number of issues that have occurred since then. On the party's second minor child, Delilah, an interim order was entered by this court on April 19th of 2023 that gives my client sole legal and physical custody and grants the mother only supervised parenting time. There is a pending CPS investigation as it relates to both children with allegations of physical abuse and inappropriate touching on the part of the mother's boyfriend. The mother claims that CPS investigation has wrapped up, but we have not yet gotten any sort of CPS report from CPS for a conclusion as to whether the investigation is simply going to be closed or if there's further continued services required. We are also awaiting a SANE examination, SANE, of both children that is currently pending with the police. On April the 20th, which is last week, the mother texted my client, quote, "I'm going to kill myself. I'm over it. Have fun raising them kids by yourself because I can't deal with your back and forth bullshit," unquote. She was subsequently hospitalized here in Battle Creek at Bronson. And the reason we know that is my client was still listed as her emergency contact, and the hospital called him. On Saturday, Ms. Hall, in violation of the court's order, previous order signed on April the 19th, came and took Delilah from Dylan, and to my knowledge has not given Delilah back. What we are requesting at this point as it relates to Dylan is a temporary order allowing the minor child to live with the defendant and with my client, the father, and supervised visits to the mother. In light of recent events, we are requesting that the mother submit to a psychological evaluation with Dr. Haugen. We are further requesting, based on the statements made by the child, that the mom and her boyfriend are smoking something in aluminum foil. We are also requesting that the mother submit to drug testing. We request that Dylan continue his counseling at Summit Point in order that the mother's current boyfriend, I believe his name is Christopher Halleck, not be around Dylan if she is to exercise any parenting time. We request that my client's child support be suspended effective the date of filing this motion, as the child has been as Dylan remains in his care, and given the actions of the mother over this weekend, we request that the court enter an order requiring that law enforcement both enforce both parenting time orders. Finally, I would note, Your Honor, that we have a scheduling conference scheduled for, I believe, this Wednesday, and the court may want to address that issue as well.
Okay, okay. Okay, Ms. Cornell, what's your response to the motion?
My name is actually Emily Hall. Cornell was my maiden name. But my response to that is I was never hospitalized for anything that day. The police showed up at my house. Well, first at my job, embarrassed me, and then came to my house and we had a 2-second conversation and they left. And I never was hospitalized. I can prove that. Also, so the CPS case it's pending closing, but I have a text message from Carla, the CPS worker, saying that there is no findings. And if anybody needs to know that she can give that information, and I have her phone number and everything. And that's also the text message that the police saw. And they also talked to Carla as well when the incident on Saturday when I took Delilah happened, because it says in the order that if the CPS investigation is no longer, like, there's no findings or anything like that, that there's nothing. And there has never been a CPS case open on Delilah anyhow. It's just on Dylan Jr.
Okay.
Your
Well,
Honor,
go ahead, Mr. Umlauf.
At this point, Your Honor, she has not submitted a motion to modify the interim order, and she even acknowledges that the CPS case still remains open. I think I heard her acknowledge the CPS case remains open as we're still awaiting a final report. Until we get that final report, I think the interim order should remain in place, and the order that I just requested be entered on the part for Dylan. Thank you.
Okay. The court will, at this point, I don't know what's happening with the CPS matter, and obviously it's up in the air at this point. Supposed to be closed, but I don't know what the findings are. The court will continue and will enforce its orders in this matter. So those orders will remain in full force and effect until they're changed.
Your Honor, can I say something?
You can, go ahead.
I have text messages from the CPS worker saying that there are 0 findings and that if anybody needs to contact her about this, that she is willing to say that.
Okay.
And the police talked to her as well on Saturday.
When she gets a report done and the case is closed, then we will address it. I'm not going to address anything based upon hearsay and what somebody has said, or we have to call them, et cetera. So,
okay. So the CPS case is only on Dylan Hall Jr. I have Delilah currently. She doesn't have a CPS case open. There's no case open.
But Dylan was covered by the interim order of the court, correct?
Your Honor, actually, and I spoke with Bridget Boozer about this yesterday, just to clarify, because I was confused as well. Delilah is the child that is covered by the interim order, which is why we're here today regarding Dylan.
Okay. Well, the court will continue to enforce its order as it relates to Delilah in this particular matter. So if Delilah, pursuant to that order, is to be in the defendant's custody, she needs to be returned to the defendant.
There is no custody order on Delilah. On the paperwork, it just says DH. Both my children are DH. So which one are we talking about? Because I'm confused and I don't know what's going on at this point.
Okay, well, from what Mr. Umlauf said, that would pertain to Delilah. And it's probably some of the confusion when we start trying to protect identity and having privilege issues, and we put in initials. And unfortunately, in this case, it's the same initials. So the court will continue that order as it relates to Delilah. And so she will have to be returned to the defendant's care at this point. What happens, the court is going to, court is going to suspend that child support as it relates to Delilah as well, because of the fact that she's in the defendant's care.
The child support is regarding Dylan James Hall Jr., not Delilah
Okay,
Hall.
well, then it wouldn't be applicable then. The court at this point is not going to make any additional orders until such time as we can figure out what's happening in the case, which would require a hearing in this particular matter. So once we have that hearing and can filter everything out, then the court will again enter an order at that particular time. So.
Hey, sir, excuse me.
No, you have an attorney, your attorney can speak. You don't.
I don't know how to get a hold of him off of Zoom.
Okay. Well, Mr. Unloff will contact you after the hearing. He can speak to you at that time.
All right, thank you, sir.
Okay.
Your Honor,
That will be the order of the court at the interim time until such time as we can get you in to have a hearing. The court will end this matter at 10:01 a.m. You're free to go.
Your Honor.
Yeah.
I just wanted to clarify for my notes to make sure I didn't misunderstand the court. Did I hear the court is going to deny the motion as it relates to Dylan at this time?
Yes. Yes. I'm not going to make any additional orders till we have an evidentiary hearing.
Okay. All right.
Thank you. You're free to go.
Thank you, Your Honor.
Good afternoon to everyone. Ms. Boozer, on behalf of plaintiff, I note obviously the matter is before the court in this particular matter, and it's my understanding that based upon what I guess maybe my office has been in contact with you, that the only issue that we're addressing today and the only issue between the parties is parenting time. Is that correct?
Yes, Your Honor. My understanding from communications is that this specific hearing is addressing the issue of parenting time relative to Dylan Hall Jr., the child born prior to the marriage and the subject of the prior order.
Okay. And Ms. Hall, is that your understanding that the issue before the court is simply the parenting time for Dylan Hall Jr.?
I guess that's what my understanding is. All I know is that it was an evidentiary hearing for today. But both my children were actually born before the marriage, so I don't know if that has anything, like if that is prevalent.
Okay. Well, apparently, Ms. Hall, what the defendant through his attorney is stating that there are no issues as it relates to Delilah in this particular matter, and that's my understanding. Is that correct, Ms. Boozer?
No, Your Honor, that I wouldn't say that's correct. I would say that, Your Honor, there is a current order that we will be filing to modify regarding Delilah based on a temp order that was entered before the cases were consolidated. I mean, if the court's so inclined, we can address both children at this hearing. But I was advised, the staff had said it would be limited just to the one child because we were going to move forward with a new motion regarding Delilah. But I'm open to whatever the court feels is judicially, in the interest of judicial economy.
Well, at this particular point, it's not the court's decision. If in fact appropriate motion has not been filed as it relates to Delilah, I don't see how we can have an evidentiary hearing just sui sponte, or I guess at this particular juncture without providing notice to the defendant.
I have no problem proceeding under the current motion, Your Honor.
Okay. So, Ms. Hall, apparently we are just dealing with Dylan Hall Jr. At this time, they intend to file other pleadings as it relates to Delilah. And if so, they do, but we're just proceeding today on Dylan. So for purposes, I guess, of this hearing to determine, obviously, because there does appear to be some confusion in this particular matter. Ms. Boozer, you can go into your opening statements at this time.
Your Honor, I would just have a brief opening statement. Your Honor, we're asking the court for a specific parenting time schedule for Mr. Hall and Dylan Hall Jr. The prior order provides vis-a-vis, it was a prosecutor order that Mr. Hall have only parenting time as the parties agree. And at current, Mr. Hall has Dylan Hall Jr. in his he's providing custodial care to Dylan Hall Jr. due to a series of concerns over Ms. Hall and her partner and some concerns over safety at her house. And so Mr. Hall has been the custodial parent to speak for the last several weeks or so. And so at this juncture, we're going to ask that Mr. Hall have at least equalized parenting time, if not the current schedule that is going on, that he have parenting time during the week and that the parties alternate weekends. And as the court's aware, he doesn't have a specified parenting time schedule. So at current, we're asking that the status quo of what's going on be maintained, or alternatively, that the parties have equalized parenting time until this case with both children is set for trial. Thank you.
Ms. Boozer, how can you ask for equal parenting time if the issue of custody is not in dispute?
Because, Your Honor, the parenting time, the custody was determined prior to the order, and at current, the Ms. Hall has basically indicated to our client that she wants him to keep Dylan Hall Jr. and she wants to have Delilah, and so for them to split it. And that's my understanding, that they actually had an agreement. But since then, that agreement is kind of it's been kind of a teeter-totter. So I'm not sure if she's in agreement with that anymore. But I understand the issue of custody.
Let's find out. Ms. Hall, in this matter, it's been stated that you may have at some point had an agreement that Dylan would stay with the plaintiff. Is that your understanding, or what's happening?
He wrote up something with somebody about how he wanted things to go, and I had several disagreements to it, so I never ended up agreeing to anything. But that's something he wrote up, and I have seen it. I never agreed or disagreed to it.
Okay, well, what I'm trying to discern is, obviously we can go through a full hearing, but the court would like to discern if we don't have a dispute. I don't want to go through a whole hearing and then find out, 3.5 hours from now that we're really not disputing anything. So if you could enlighten me, is there a dispute with Dylan staying with his father and coming to some sort of an amiable resolution on parenting time?
Well, I honestly, all of this is just, I don't even know what to say, quite honestly, because I have paperwork that you also have. He has made up so many allegations and everything to what's going on, and that's the only reason I don't have any of
hold
this.
on, ma'am. I don't care about the allegations. I want to know what's been happening, what is agreeable, regardless of the allegations. I mean, the allegations can go either way and can be going back and forth. I'm just trying to discern if we have some resolution so that we don't go through with the hearing. That's all.
I just want my daughter, because all of this is just him being angry about the divorce. That's why he's keeping my kids from me. And that's why I'm
okay, ma'am, Delilah isn't the subject of this hearing. We addressed that probably 5 minutes ago and stated that she was not subject of today's hearing, that they may file something with regard to her, but it's not the subject of today's hearing. Ms. Boozer, do you think there'd be any utility if we had you and Ms. Hall go in a breakout room and talk? And
I would be glad to speak with her. I feel that would be an appropriate use, like 10 minutes or so.
Okay. Ms. Hall, if we put you into a room just with Ms. Boozer and you could talk about what your disputes are or not, again, as it relates simply to Dylan, then perhaps we have agreement, perhaps we don't. If we don't, we'll come back in and have the hearing, but I don't, again, want to go through the hearing if we don't have a dispute.
all right.
Okay, we'll put the two of you in a breakout room and you can talk, and we'll give you about 10 minutes and then bring you back in. And Mr. Hall will just put you back in the waiting room. Ms. Boozer, go ahead. Thank
you. Your Honor, thank you for the court's time in trying to work out an agreement. It's my understanding, based on speaking with Ms. Hall, who represents herself, and then subsequently meeting with Mr. Hall Sr., that we did actually reach a resolution on the issues of custody, child support, and parenting time, because there was some stuff priorly worked out. And so we were able to actually work out all three matters regarding Dylan Hall Jr. separately, with the understanding that we will come back on the issue and I will meet with Ms. Hall on Delilah.
Okay.
So if the court would like, I can put that on the record.
Yes, please do.
Okay. Thank you, Your Honor. It's my understanding that the parties are agreeable to the following terms relative to Dylan Hall Jr. specifically and only: that the parties will share legal custody of Dylan Hall Jr., that the parties will share physical custody of Dylan Hall Jr. The parenting time schedule will be Mr. Hall Sr. having Dylan Hall Jr. Monday through Friday, and then the parties will alternate Friday, Saturday, and Sunday nights. So each party will have a 3-night weekend every other weekend. And that Dylan Hall Sr.'s current support obligation will be held in abeyance because he would have the child the majority of the time in his home. And that the matter of support only for Dylan Hall Jr. will be referred to the friend of the court to do an investigation.
Okay. Ms. Hall, is that your understanding of the agreement?
Yes, Your Honor.
Okay. I guess, Ms. Boozer, just to clarify, you stated as far as the Monday through Friday and then the alternating weekends, are we doing alternating holidays as well?
Oh, yes, Your Honor. Thank you. We would adopt the Calhoun County standardized holiday parenting time schedule unless the parties agreed in writing otherwise relative to Dylan Hall Jr.
Okay. Okay.
And I will attach that for the parties' information when I submit the order. So Ms. Hall will have a copy and Mr. Hall will also have a copy.
Okay. With that, Ms. Hall, is that your understanding of the agreement?
Yes, Your Honor.
Is that acceptable to you?
Yes, Your Honor.
Are you entering into this agreement freely and voluntarily?
Yes, Your Honor.
Has anybody threatened you, coerced you, used any undue influence, pressure, or promises to get you to agree to this?
No, sir.
Okay. And you believe that it is in Dylan Hall Jr.'s best interest that the court adopt this agreement?
Yes, Your Honor.
Okay. Ms. Boozer, if you'd inquire of your client.
Thank you, Your Honor. Mr. Hall Sr., can you hear me?
Yeah, I can hear you.
Okay. You've heard the record or the agreement that was put on the record. Are you in agreement that is the entire agreement for you and Ms. Hall relative to Dylan Hall Jr.? Are you frozen?
It does look like he is.
Okay. Dylan, you may need to log out and log back in. You're frozen. Okay. Dylan, you had an opportunity to listen to the agreement that was put on the record. Do you agree that that is the complete understanding of your agreement?
Yes, but
hold
this
on.
weekend is Mother's Day weekend, so
Hold on one second. We can talk about that afterwards, Dylan. Hold on one second.
Okay.
And do you understand that the issue specifically concerning child support will be referred back to the friend of the court and that your current obligation will be held in abeyance until a determination can be made?
yes, ma'am.
Okay. And do you believe that this is in Dylan Hall Jr.'s best interests?
Yes, it is.
Okay. Your Honor, I have no further questions for my
Okay.
client.
The only thing I would say is Mr. Hall brought up that this weekend coming up is Mother's Day, so it'd probably be good to put in the order that the defendant's weekend is this coming weekend, which encompasses Mother's Day, and then we alternate thereafter.
Yes, Your Honor.
Okay. That'd be fine. The court will, in fact, adopt the agreement of the parties, as it does appear to be entered into freely and voluntarily by both of the parties. Does appear, as the parties have stated, to be in Dylan's best interest. So the court will simply ask that Ms. Boozer would prepare the appropriate orders and submit those under a 7-day notice of entry.
Thank you, Your Honor.
Thank you all. I think you'll be happy with the fact that you've been able to come to an amiable resolution in this matter. The court will end the matter at this hearing at 2:05 p.m. You're free to go. Have a good day. This matter is before the court on the plaintiff's attorney's motion to withdraw in this matter. They've alleged a breakdown of the attorney-client relationship, although unfortunately, Mr. Umloff, there's no reason stated in the motion, so I have no idea why. Maybe you could give me some insight on that.
Certainly, Your Honor. I am covering for Bridget today, but I have worked on the file with her throughout the time that Mr. Hall has been a client. Unfortunately, at this point, Bridget and Mr. Hall have a fundamental disagreement about legal tactics and strategy and the best route to take to get the best possible outcome for the client. And for that reason, Mr. Hall is no longer taking Bridget's advice, and we are requesting, therefore, that we withdraw. We can no longer zealously represent Mr. Hall at this time.
Okay. Mr. Hall, are you opposing, or you agree with allowing Ms. Boozer to withdraw?
I've got a couple, yes, I don't agree with this. So there's a couple things that she didn't do correctly. FOC can't uphold the custody orders because you guys didn't use the full names of my kids, because both my kids got DH. Their initials are DH. And I've been doing everything that Bridget's been telling me to do. I have not once not heeded her advice. There's a couple questions where me and her we argued a little bit because I wasn't understanding what she wanted, but there's not one time where I ever did not agree with what she was telling me to do.
Okay. Okay, Ms. Hall, what's your position, if you have any, as it relates to this motion?
I don't have any input.
Okay. Well, these matters are oftentimes very difficult because obviously sometimes you just have a difference of opinion or how things are done. But unfortunately, in this matter, Ms. Boozer does not believe that she's able to represent Mr. Hall at this particular point. He doesn't seem to have the same issue relating to her, but again, it is a two-way relationship, and if in fact the parties are not able to communicate with the attorney, or the attorney is not able to communicate effectively with the client, that presents a problem for the client. So what the court is going to do, the court is going to grant the motion to withdraw. So Mr. Umloff, make sure the court get us an order allowing the withdrawal, and then Mr. Hall, you'll have to acquire other representation. Okay, sir?
Sir,
Your
before
Honor.
we go, I would like, before she's able to withdraw, I need her to amend the custody agreement, so friend of court knows what to do.
Okay, well, what's going to happen is I'm allowing her to withdraw, and so she's not going to be representing you. So whatever attorney that you get is going to have to finish the work, apparently, that she's had some issues with or have not been able to complete. So you'll have to get your other attorney to do that, or you can contact the front of the court and attempt to resolve things as well.
Your
Derek
Honor.
gave me some information on how to do it myself. It's just the names that need to be put in there. That
Okay.
Everything else is great. It's just, since you guys use the initials, they
Okay.
can't,
Well,
there's strict
I'll-
guidelines for
I'll
friend
tell
of
you
court.
why that is, sir. What's happened is with a lot of the confidentiality and stuff that used to be where they put full names in, they put dates of birth, et cetera. And as a result of change in the court rules and statutes, they've now come out and stated that they should use initials as opposed to names. Unfortunately, as you said in your case, the initials are the same, that creates a problem. But it seems like you could, if you wanted to do an order correcting that and maybe you put one of the names in and not the other one, you could do that and send it to, again, to the defendant. If she agrees and signs that, then you'll be able to get the order entered and simply do a corrected or modified order with, could be everything you have except for putting one of the names in, and that should be able to accomplish what you want, sir.
All right, thanks, sir. I appreciate
Okay,
it.
Your Honor,
thank you. Yes,
Bridget did submit an order to withdraw as counsel with
Okay.
a motion.
okay, we'll get that order and we'll get it entered then.
Great, thank you.
Thank you. Good afternoon. I'll start with you first, Mr. Hall, because you're the plaintiff. Tell me what is happening in the case at this point.
What's happening in the case is, she took Delilah. I've been trying to get her back. And so far, that's the only thing that's going on.
Okay. At this point, court notes we don't have mediation did not occur as the defendant failed to contact the mediator or to pay the mediation fee. So at this point, all we can do is set the matter for trial. I'll ask Mr. Hall, how long do you think we're going to need to try this matter?
I'm not understanding, sir.
Well, I'm asking the amount of time you believe it'll take to try the case. Are we talking a day, 2 days, more days? What?
Well, if we can get the mediation scheduled, we can have all this sorted out through a mediator. I mean, I don't know why we got to go to trial.
Well, you could, but the defendant did not contact the mediator, nor did she pay for the mediation fee. So the mediator is not going to mediate the case. I guess I'll ask you, Ms. Hall. Ms. Hall, was it your intent to mediate and there was some confusion or what?
I can't afford that at all. There's no way that I can afford
Okay, then you'll end up going to trial then at this point.
That's fine with me. The only thing that we're fighting over at this point is our daughter.
Okay.
This really has nothing to do with anything else. Our property is already split and everything.
Okay. Well, what the court will do is the court will set the matter for a 1-day trial. And hopefully we can get the matter resolved at that time.
Sir, when is this going to happen? Because I'm going to have to take work off for that day.
Yeah, you will have to do that. I don't know. What I'll do is we'll try to get in touch with both of you and find out what works in your schedules. If we're not able to work it into your schedules, the court will just set a date and then you'll have to appear on that date, but we always try to work it out if we can. So hopefully we can, and then we can set it for trial. And the trials, I will tell you, the trials will start promptly at 8:30 a.m. So be present for that. Then we will proceed. Be ready with any witnesses that you have. There was a case scheduling order entered in this matter back on April 26, 2023. It set forth what is required for the trial to proceed as it relates to, again, your disclosure of exhibits, your disclosure of witnesses, etc. So make sure that you read over the case scheduling order, because if you have not properly filed the paperwork necessary, you may not be able to get witnesses in or exhibits. So I'll just draw that to your attention. Okay. Anything else, Mr. Hall?
So are we looking at a couple weeks out?
Probably a couple weeks. Yes.
Okay.
It
If
might
we
be
come
longer.
to-
I don't know. It could be longer. I don't.
If we come
Totally
to an
check.
agreement before then,
If you come to an agreement before then of course, there's no need to go to trial, but that's up to you.
all right, I guess me and her can sit down and figure some stuff out. Because I can't keep missing work, sir.
Okay. Well, then you'll have to try to do that, and I suggest you do it right away so that you can get it resolved. We will be in touch with you probably later today or tomorrow to try to schedule the trial.
All right,
Okay.
so if we do, one more question. So if we do solve and end this matter today, do we just call your office and say, hey, we reached an agreement, or?
Yes, you have to call my office. Then what happens, you'll have to do the paperwork for putting together the judgment of divorce and the uniform child support order, et cetera. But you can get that off michiganlegalhelp.org. So.
I already got the paperwork and everything. I've already filled all that out.
Okay.
So all we got to do is
Okay,
sit down and discuss what we need.
that's good.
So me and her
Okay.
will,
See if you can't do that, and hopefully you can, and we can get it resolved and then proceed. Okay? Anything that
thank
you have, Ms. Hall?
No, that's all. Thank you.
Okay. Okay, thank you both. Mr. Hall, good morning. This is the time and place set for the trial in this particular matter. Court will note that we had mentioned to you that we're going to wait for the defendant to again appear. We're going to give her 10 minutes. And then you mentioned that she has started a new job and was not able to get off from work. Is that accurate?
That is accurate, sir.
Okay.
We've been talking and trying to work some things out, being civil. We decided what was best for our kids because what's decided best for our kids is to stay friends. And let them know that mommy and daddy aren't fighting.
Okay. So with that, does that mean, have you come to an agreement as to what you were going to do or not?
Yes, so we discussed to actually go to counseling.
The two of you go to counseling, and what type of counseling is that? Is it, there's a lot of counseling. There's marriage counseling, there's, co-parenting counseling, there's.
That is, I think what she said was marriage counseling. She told me she left without putting her full foot forward. So we're going to try that route. And if that doesn't work, we'll probably come back and do a little quickie divorce.
Okay. Well, what's going to happen if you're the plaintiff, you have a right to dismiss the case if you wish to do so. Court's not going to leave it open though, because it's already 146 days old. So,
no, see, that's, the kids are with me. They've been with me for a minute now.
okay.
They've got a routine. Junior's starting school here in Eaton County, September 5th.
Okay. I do note that there was a temporary order back on April 13, 2023. Then we did a subsequent order on May 9th, 2023. I'll let you know if we dismiss the case, those orders get dismissed. You understand?
Well, so you ruled on me getting custody of my son. That's getting dismissed?
Yes, if you dismiss the case, that dismisses those orders. Those orders do not exist then.
Oh, I didn't know that.
Yeah. Yeah, you can't dismiss a case and then say, oh, we want to rely upon the orders of a dismissed case, because those orders don't exist then. If we complete the case and then there's a final order, then in fact that order proceeds even though the case gets dismissed. Well, the case gets finalized, let's say, not dismissed. If you dismiss the case, then all of those orders that have been entered to this point would get dismissed as well.
Oh, no, I don't want to dismiss the orders. That's something me and her discussed. We wanted to go to marriage counseling and see if we can work this out.
Okay, but I'm just telling you, that's fine, but I can't keep the case open while you're in counseling to see if it's going to work out, because the case is already 146 days old. I don't know, maybe it takes you 6 months, 9 months, a year to work things out. And the court, I just will not leave the case open that long.
So, can we, I don't get it. We decided the kids would stay with me. So she wants an order in place stating that the kids will stay with me because right now her living situation is not right.
Okay,
The other day, Chris threw her phone, broke her phone. They got in an argument. Chris pushed her. I'm not having
Okay.
my kids there.
okay. Well, that's fine. We can enter, if you don't wish to proceed with a, I'm just trying to think the way to do this. If you don't wish to proceed with the divorce, but you want to work some of that out, we could do a final order for custody, parenting time support, and that would, and then dismiss the balance of the case if you wish to do that.
Yeah, let's get the final, let's get the custody orders like you said. And we'll go the route you just said, sir.
Okay.
But Delilah does have daycare scheduled for that tap zone there on M66.
Okay, and what? And you're telling me that why? Why was that?
Oh, I'm just that's daycare. So she's got a place to go so I can work. So
Okay,
it's a Head Start program so she can get ready for school
okay,
in the next couple of years.
okay. Well, let's do so. I am going to need to take some testimony from you to establish a basis for custody. So what I'll do is have you raise your right hand, be sworn in, and then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do, sir.
Sir, as I'd stated to you previously, that you had a temporary order of 4/13/23, and then another order on May 9, 2023, which granted you physical custody. The second order, you agreed to a joint legal custody of Dylan, but not with regard to Delilah. Let me ask, prior to those orders being entered, where were the children primarily at?
They've been with me this whole time, sir.
And that's from the date of separation?
That is from the date of separation, yes.
Okay. You have the date of separation as January 10, 2023, and the defendant in her answer said it was March 1, 2023. Could you clarify the date of separation?
The day she said March of 2023.
Yeah, she said March 1 of 2023, and you had January 10.
Well, she was in and out of the house for weeks on end in January. I had no idea where she was. So that's why I put the separation at that time.
Okay.
Then I asked her what kingdom she wanted to be in. Like, if you wanted the kingdom I'm going to build or you want the kingdom he's going to build. She chose him.
Okay. So when did she, so sometime in January is when she started to not be home, correct?
Yes, sir.
And from that date to the current date, have you been the one that the children have they've been principally in your care?
Yes, sir.
And how, let's say since January to the current date, how often has she, let's say how many times has she seen the kids?
You mean kids?
No, the kids, Dylan, Delilah.
Last weekend was her first weekend in over a month.
Okay, and let's say since January, how many overnights has she had the children?
Since January?
Yes, approximately.
None. And she used to come in the morning, grab the kids so I can go to work around 2:30. But when I got home at 11:30, the kids were sound asleep in bed and she was nowhere to be found.
Okay, and that's happened since January?
That's
Or that happened in January?
that happened in January, sir.
Okay,
And I tried to call her on the subject and she wouldn't pick up my phone.
okay. And let's say since the time that happened, and let's say since the time that she was out of the house and wasn't coming in the house, how often has she seen since January? And you said there were times that she'd come in when you were working, and then when you get home, she was gone. Is that accurate?
That is accurate.
Okay.
Let's
say since January, starting February 1, from February 1 to the current day, how many times has she had the children with her?
About 8 hours a day, because she was watching the kids while I was working 60 hours a week.
Okay. And was that every day?
No, that wasn't every day. Around January 1st, I was having to take multiple days off work because she refused to show up to babysit the kids.
Okay.
So I could go to work.
Okay. When did she leave the house and she was gone from the house completely?
The day I dismissed her from the house was the day I asked her what kingdom she wanted to be in.
Okay, I'm not asking that. I'm asking what day was that? Are we talking January 25th, February 4th? When?
That would have been like end of February.
Okay. And since the end of February to the current date, how often has she seen the children?
There was a good like 3 weeks where she was seeing Junior every other weekend. Then she told me she didn't have money and she couldn't afford, and Chris wouldn't let her come see the kids. So like I said, there was a month chunk in there that she didn't Zoom call. She didn't get Junior on the weekends. On the spot we decided to meet in Bellevue at the park, She's been no shows.
Okay. Well, what I'm trying to discern, sir, is the time that she's been with the kids and the time that she hasn't, because that's important, obviously, in the case. So you said from the end of February through the current time, you said there are 3 weeks, about 3 weeks where she had alternating weekends, but then she didn't see them. So that's what I'm trying to discern is when was the date that she really stopped having contact with the children?
The day you entered the temporary order on Delilah is the day she.
So April 13th was the date we entered the order.
You entered the order there, then you granted her every other weekend, May 9th, and she went a while getting him every other weekend. Then she went for a month, no contact at all.
Okay. Okay.
But then, sir, like we started talking every day. I've been letting her Zoom call the kids because she wanted to be back in their lives. She's been trying to get away from Chris.
Okay.
And
When was it that she began Zoom calling the kids?
again, that would have been it's been about a week. Then I let her come to juniors karate yesterday to see the kids also.
Okay. So for about a week, she's been Zoom calling the kids.
She's been Zoom calling the kids. She's been in constant communication with me. She's been, I just think a light bulb popped in her head and said, hey,
Okay, well, tell me a little bit about what's the, do you have a relationship with the children such that you exhibit love, affection, and have emotional ties? I mean, are you bonded to the kids?
100%. Am I bonded or is she?
Are you?
100% am I bonded to.
And what do you point to show that you have a bond with the children?
What did I point to?
Yeah.
I'm not following.
Okay, well, how is it exhibited? How do you know that? You say I'm bonded to the kids. How do you know that?
Wow. Well, I am their father, so like me and Junior, when we bond, we go out and shoot baskets, like hoops. We talk, we communicate that way. That's how I was raised. So he opens up when we do that, and we bond in that way. And me and Delilah, we go for bike rides. We sit there and color on the floor. Like me and Junior, we go to karate. And that's teaching them about discipline and stuff. And we bond in that way. We go out after karate, we get ice cream. We communicate that way. But ever since we've been starting to go to church, my kids have been better off.
Okay, what church do you go to, sir?
I go to the Community Baptist and off of St. Mount Hope Highway here in Lansing.
Okay. And how you go? Are you a regular church goer?
Yeah, I go every Wednesday and every Sunday.
Okay. And the children go with you?
Yes, every Wednesday and Sunday.
Okay. Does Miss Hall, does she attend church?
I asked her to attend multiple times, but she grew up in a Catholic high school, meaning in a
Okay.
Christian high school. And she had that stuff pounded down her throat. So she's a Ray right now when it comes.
Okay, my question was, does she go to church or not?
Oh, then no,
Okay.
sorry.
Do you notice as far as the children, when we talked about the bonding, are there signs of affection that go between you and the kids to you?
Yeah.
And how's that exhibited?
Well, when I come in the door, my kids run and give me hugs. They hang to me tightly. Like whenever there's a problem or something scary happen, they come to me and they know I'm their protector.
Okay. And you say that your son will be going to school, or do you engage in any, let's say, educational activities with the kids?
Yes, I do. I got charts downstairs, like number charts downstairs, letters. Like my daughter is doing, she has these little animal blocks. She puts them in the puzzle, and before I let her put them in the puzzle, she's got to tell me the animal name.
Okay.
Junior can count to 20. I'm teaching both my kids how to read right now. Junior can read and do a lot of sight words. He's a very smart kid.
Okay.
And he helps me fix the cars and stuff. I teach him about life when we're doing that.
Tell me, since she left in approximately, let's say, February, has she contributed anything for the financial care of the children in the way of food, clothing, medical care, any other type of care? Has she provided you with any money?
She has not provided me with any money. No.
Okay. If she didn't provide you with money, has she provided you with any direct care as far as buying any food, clothing, or anything of that nature?
When Junior's over there, she goes out and buys him clothes. Yes.
And how long have you resided in the address that you're at?
Since the middle of May. Well, that's total, or just since I moved back from Battle Creek?
You can tell me since May is when you were back at your current address, and where were you prior to that time? And where is that located?
Right off of Dickman. Right
Okay,
there in Springfield. Barberry Drive, Barberry Townhomes.
okay. And how long had you resided at that address with the children?
We were there for a year.
Okay. At the current address that you're at, I take it because you're going to church in Lansing, it's in Lansing?
No, I live in Eaton County, sir.
Oh,
I live-
Eaton?
no.
Okay,
I live in Charlotte.
okay. And do you plan on staying at that address?
Do I plan on staying in Eaton County? Yes.
Okay. So you have no plans to move at this point?
No, because my kid's education is more important than me.
Okay. And do you feel that, well, tell me, how do you feel? Do you feel that the defendant is in a stable situation?
I do not think she's in a stable situation, no.
And why do you say that?
Gotta go. I'm in court. Sorry about that. My oldest daughter just come in.
Okay.
So you, what was your question? I'm sorry.
The question was, why do you feel that the defendant's household is not a stable situation?
Well, she's getting harmed. She's getting beat. She's getting, my kids were being assaulted. And she told me when I saw her yesterday that she had to get out of there because Chris is hurting her. Her phone that I bought her a year ago, Chris threw it and shattered it. So that's why I think it's a not stable situation for her. She needs somewhere where she can live properly.
Okay.
I'm not.
Are you currently, are you residing with any significant other or anything of that nature?
Right
No
now,
plan. What?
right now I'm at my parents' house.
Okay. So do you have any significant other at this particular point, or no one that you're seeing seriously?
No.
Okay. And other than you said the individual she's with, do you know whether she has anyone that she's I guess you'd say in a more of a permanent relationship?
No, he's the only one.
Okay. Is there are there any issues in your life that you believe that impact your moral fitness to raise the kids?
No, I don't.
How about the defendant? Is there any drinking, drugs, verbal abuse, anything of that nature that's occurring in her household?
Are you asking me if she's capable of raising our children, or is the
No,
living?
I'm asking you if there's anything going on in her household that impacts her moral fitness to raise the children.
Yes, there's concerns in that household, but she's more than capable of raising our children. Yes,
Okay.
if that's the question you're looking for.
Do you have any mental or physical health issues that would impact your raising of the children?
No, I do not.
Does she?
Yes.
And what is that?
She's been dealing with depression. I mean, I can't really tell you what happened when she was a child because all them records are sealed, but I know that she suffers from mental illness. Yes.
Okay. During the time that this matter has been pending, have you attempted to work with her to make sure that she stays involved in the children's life?
Constantly, every day, I text her. Hey, you want to talk to kids? Hey, you want to meet up so we can go to the park so you can see the kids?
Okay. I do note that back in June, we did have, there was a petition to hold her in contempt, that she was found to be in contempt at that point for denial of parenting time. Is that accurate?
That is accurate. She kind of stole Delilah when she wasn't allowed to have Delilah any overnights. So
Okay. And then didn't return her?
she did not return her. Delilah's been in my care since that date for about 3 weeks now.
Okay.
Like I said, there the light bulb just popped on and say, hey, you know, I'm doing bad. I gotta straighten up here.
Okay. And you stated that there are instances of domestic violence in her home?
Yes.
How about when the two of you were together, was there any domestic violence occurring between the two of you?
Yes, sir. I went to intervention court.
Okay.
But that happened when I was on chemo. So I was sick at the time. But I did need it, sir. It was a good education.
Okay. You mentioned that you had another daughter in your home, and how old is she?
She just turned 9. Like just turned 9.
And does she reside with you full time or part time?
Yes, I've got full custody of her also.
Okay. And what is the relationship between this daughter and Dylan and Emily? I'm sorry, Dylan and Delilah, I'm sorry.
Well, that's big sister, I can tell you that. There's not. She will protect them. She plays with them. They absolutely love each other.
Okay. Anything else, sir, that you would like me to be aware of in deciding this matter?
No.
Okay. Okay. Anything else you'd like to tell me?
No.
Okay, thank you. Well, the reason you'll see is I ask you these questions is I'm required to under the Child Custody Act, which is MCL 722.21 at SEC in this matter. And the first job that the court has in deciding custody is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time the children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The reason that's important is the court cannot change the established custodial environment unless provided with clear and convincing evidence that it would be in the best interest of the minor children to do so. In this matter, when the court had asked, the court will note that this matter was filed back in sometime in January of 2023. That see the exact date. Now, I'm sorry, the summons and complaint was in March of 2023. That as a result, on April 13, 2023, the court did enter a temporary order which placed the children in the care of the plaintiff, and the defendant was to have supervised parenting time. Subsequent to that, that was changed and modified on May 9, 2023, but still provided the plaintiff with primary physical care, but provided the parties with joint legal care of Dylan Jr. It does appear, based upon the testimony of the plaintiff, that, again, he is the one that's been providing the children with guidance, discipline, and the necessities of life and parental comfort. He talked about how the children will come to him when they need things, they'll talk to him, et cetera. So the court will find that, again, that is what's exhibited here in this particular case. The court then has to go through the 12 factors of the Child Custody Act to make a determination on custody. The first factor is the love, affection, other emotional ties existing between the parties involved and the children. The plaintiff testified about, again, the love, affection that he exhibits, talks about the children will, when he comes in the room, will run to him, they'll hug him, and they hang on him. If they're scared, they come to him. And it does appear that, again, they are bonded to him, as he stated. I've not heard any testimony about the children being bonded to the defendant. As a result, the court will find that this factor does favor the plaintiff father. The next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education of raising the children in a particular religion or creed. He testified he does go to the Community Baptist Church in Lansing, that they go regularly on Wednesday and Sunday with the children. She testimony as well that the defendant does not have any church affiliation. She doesn't go to church. He's also testified that he has the Dylan Jr., he has him enrolled in school up in Eaton, up in Charlotte, and that he's starting. He also testified about how he works with them on their numbers, colors, that Dylan can count to 20, that again, it appears that, again, he is prevails on this particular factor, and this factor favors him in contrast to the defendant, who we had no testimony on. Court, the next factor is the capacity and disposition of the parties involved to provide children with food, clothing, medical care, and other remedial care permitted under the laws of the state in place of medical care and other material needs. In this case, the testimony has been that since their separation in approximately February of 2023 through the current date being August 8, 2023, that the plaintiff is not, the defendant has not contributed to the financial support of the minor children in this particular case. He did testify that when Dylan is with her, that she will buy him clothing, but that is the extent of it. The court will find that this factor does favor the plaintiff father. Next factor is the length of time the children have lived in a stable, satisfactory environment, the desirability of maintaining continuity. He's testified that he had previously been in address in Battle Creek for about a year. He's now living with his parents, and that has happened since mid-May, that he has no plans to change in that situation. He did state that he has been informed by the defendant that she's residing apparently with a boyfriend, but she has testified that it's a kind of a tumultuous relationship, that she has been assaulted, the kids have been assaulted, and as a result that she has to get out of there. So clearly that is not a stable, satisfactory environment. The court will find this factor does favor the plaintiff father. Next factor is the permanency of the family unit, the existing or proposed custodial home or homes. He stated that he does not reside with any significant other, does not have a significant other. The court again notes that the defendant does, but it's again a tumultuous relationship. So the court will find that this factor does favor the plaintiff father. Next factor is the moral fitness of the parties. There's been no testimony about moral fitness. The court will not weigh that in fact in favor of either of the parties. Next factor is the mental and physical health of the parties involved. The court will note that in this particular matter, he states that he has no mental or physical health issues in this particular case. However, the defendant has suffered from depression and mental illness since being a child. Court will find that this factor does favor the plaintiff father. Next factor is the homeschool and community record. The children are not of an age to have a school or community record, and the home record is minimal, but it does appear that again, the plaintiff is providing that direction and assistance to the kids as it relates to their education, and is again providing them with a good home environment that we've previously testified to. So this factor would favor the plaintiff father. Next factor is the reasonable preference of the children. If the court determines the children to be of sufficient age to express preference, I did have opportunity to speak to Dylan Jr. And again, I'm taking that into consideration in this matter. Next factor is the willingness and ability of each of the parties to facilitate a close and continued parent-child relationship between the child and the other parent. And in this matter, the court heard the testimony of the plaintiff in which the defendant had denied him. She had taken Delilah at a time when she could not take her because she was under an order for supervised parenting time, that she took her for a number of weeks. And in fact, the court did find the defendant to be in contempt of court back on June 15, 2023, as a result of that action. And the plaintiff was awarded 4 weeks of make-up parenting time. As a result, the court will find that this factor does favor the plaintiff father. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. The plaintiff testified about that there were some acts of domestic violence in the home when the parties were together, that he had to go to some sort of an intervention court, as he stated. The court also notes he's testified about domestic violence occurring in the defendant's home. So the court is not going to weigh this factor in favor of either of the parties. Next factor is any other factor considered by the court to be relevant. The plaintiff testified that he does have a 9-year-old daughter who resides with him full time. He has full custody of her, that she acts as a big sister to both Dylan Jr. and to Delilah, that they love each other, have a good relationship. The court is taking that into consideration and finds that that factor does favor the plaintiff father in keeping the children all together. When the court does this, because the established custodial environment is with the plaintiff, he need only show by a preponderance of evidence that it is in the best interest of the children that the children remain in his custody. However, the court will find that the evidence has shown by clear and convincing evidence that it is in the best interest of the minor children that they continue to remain in his care. The court will therefore grant the plaintiff full and sole custody in this matter. Court then has to look at parenting time pursuant to MCL 722.27A. And again, the considerations the court has to look at. Those factors are there any special circumstances or needs of the children? There's been no testimony about that. Next factor is whether the children are less than one. There's no testimony about that. The children are not less than 1 year of age. Next is the likelihood of abuse or neglect of a child during parenting time. There's been testimony that again, that from the plaintiff that the defendant herself had stated the children had been abused apparently by the live-in boyfriend. The court would note that the court did initially in this matter, based upon various allegations, and at the hearing did in fact determine that again, the only parenting time should be supervised parenting time, and did put an order in place to that effect. Next factors, likelihood of abuse of a parent during the exercise of parenting time, not applicable other than as previously stated. Next factor is the inconvenience or burdensome impact of travel on the child. Parties reside reasonably close together, so the court will find that not to be a burdensome impact. Next factor is whether a parent is reasonably expected to exercise ordered parenting time. In this matter, although the defendant did not have any stated parenting time, that again, she has been sporadic at best in exercising the parenting time that she did for a period of time, as the plaintiff stated after the May 9th, 2023 order, that she did exercise alternating weekends with Dylan, but then she's had no contact since just a couple of those weekends, that he has been the one that's assisted and contacted her almost a daily basis of whether she wants to have contact with the children or see the children. I should have mentioned that under the prior factor, and I didn't. But the court will note in that matter that he has attempted to facilitate that. Next factor is whether a parent has frequently failed to exercise parenting time. Obviously, she has failed to exercise parenting time, and that she's not taken the children as she's been provided the opportunity to do so. So the court will consider that. Next factor is threatened or actual detention of a child. Again, there was this incident that occurred in which she kept Delilah, and she was held in contempt back on June 15th, 2023 as a result of that. So the court is taking that into consideration. And any other considerations, the other considerations would be considerations of, again, the best interest of the child test under the Child Custody Act. The court is taking those into consideration this matter. As a result, what the court is going to do is simply order that the defendant would be entitled to a parenting time at all times and places to which the parties may mutually agree. So that will be up to the two parties to agree as to the parenting time, but I'm not going to put in place at this time any scheduled or regular parenting time for a number of reasons, due to the upheaval in the defendant's home. Also, the fact that she has failed to show at prior hearings. She failed to show to the hearings in June of 2023. She's failed to show up to today. The court notes it is now 9:22. The matter was set for 8:30. She is not shown and has not contacted the court at all about hearing or anything else. And as a result, I thought it'll be incumbent upon the defendant, if she wishes to pursue parenting time in the future, that she will have to file and provide the court with a appropriate basis for the court to enter a custody or parenting time order at that time. Court likewise has to address the issue of support. I've not heard any testimony from the parties. I'm going to leave that up to you, Mr. Hall, to put in place a support order. In this case, what happens is when you put together your judgment, and it would be a final judgment for custody, parenting time, and support, you'll have to do a support calculation, which you'll have to take your income, put that in the calculation. You'll have, because you have your daughter with you, your older daughter, you'll have to put her in as an other child. You want to make sure that, and then you can put in the defendant. I don't know if you're aware of what her income is. If not, the court would allow you to impute income to her of $15 per hour. That is pretty standard in this area at this particular time. And then you will come up with a support calculation, and then you'll do a uniform child support order as well.
Sir, can I put this on the record? I do make 10 times the amount of money she does.
Okay, that's fine.
Right now, I'm still paying her child support.
Okay, then obviously that's gonna be canceled. So you'll cancel that immediately. You'll put in a new support order, which will require that she pay you support based upon her income. Even though you're making substantially more, she's still gonna have to contribute something. Okay, so if you utilize a service such as MichiganLegalHelp.org, when you get to the final judgment, yours is going to be a little bit different because you're not proceeding with a judgment of divorce because you didn't want to proceed with that. Is that accurate, sir?
Yes.
Okay. So you're going to simply do a final order for custody, parenting time, and support.
Okay.
And so you'll have to do that final order. You do a uniform child support order, and you will do a judgment information form. And all that is contact information on you, contact information on her, and then you will turn all three of those items into the front of the court to get their approval. And when they approve it, then the court will be able to enter it at that time.
All right, sir. I'm sorry, but can you go over this again so I can write it down? It's just a lot of.
Well, a couple things. What happens, this is being recorded on YouTube. You can go to YouTube and review this, okay?
Okay.
So just go to YouTube, put my name in, it'll come up on today's date, and you can go over it all at that time.
All right, that works great. Thank you.
But make sure and get that in. It takes time, and oftentimes people will, when they're preparing those orders, and being that you're a lay individual, you won't know. Oftentimes they don't include everything that they're supposed to include, and the front of the court will sometimes object.
Yes.
If they object, they give you a form and they check the box up as to what their objections are, and then you've got to correct that. There's going to be provisions that appear in the orders from Michigan Legal Help that are standard provisions that are required to be in the order. Don't delete those, okay? Sometimes they talk about parenting time not occurring in countries that don't subscribe to the Hague Convention. First, a lot of times people, what is this? They have no idea. Make sure you just leave that in there because that will be an objection if you don't include that. Okay, and there's a lot of those types of objections. So the important thing is you have to know is that you're being granted sole legal and sole physical custody, that she gets parenting time at all times and places which the parties may mutually agree, and that's it. And then the provision for the support will be in a separate uniform child support order. Any other questions that you have, sir?
No, just one quick question. So you granted me custody of both kids, correct?
Correct.
Okay. That's all I needed, sir. Thank you for your time.
Okay, then what happens is we will just do it. MichiganLegalHelp.org takes you kind of through the process. It's a pretty easy process, but make sure you do it and then go back to the YouTube if you have any questions.
All right, thank you.
Okay, thank you. The court will conclude this matter at 9:28 a.m. Court will note that again that the defendant has not appeared at all. So even at this time, so we will conclude the matter. Sir, best of luck to you. I hope everything works out for you.
Dylan Hall and Emily Hall. This is that case went to trial in August. Defendant did not appear for that trial. We're just taking the proofs. Please unmute Mr. Hall. Thank you for your patience. We're ready to proceed with your case now. Okay, there we go. Thank you. This is 2023-685 DM, Dylan Hall Sr. versus Emily Hall. It is Wednesday, September 27th, 2023 at 9:05 a.m.
Sir, what we're going to do is take some testimony from you. So we'll have you raise your right hand, be sworn in, then we'll proceed.
Okay. Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. And sir, do you have the script that we would have provided you?
Yes, I do.
Go ahead. You can go through that now. You don't have to state your address if you don't desire.
All right. My full name is Dylan James Hall Sr. My address Road, Charlotte, Michigan. I married the defendant on June 12, 2021 in Lansing, Michigan, in Ingham County. I filed a complaint for divorce on March 10th, 2023. I live in Michigan for 180 days in Eaton County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all statements were true. All the statements in my complaint for divorce are still true today. There has been a breakdown in our marriage relationship such that the objects of matrimony have been destroyed and there is no remains and no reasonable likelihood that the marriage can be preserved. I do believe there is any possibility of reconciliation. My wife is not currently pregnant. The defendant and I have 2 minor children together, and their names and ages are Dylan James Hall Jr., 5 years old, Delilah Lynn Hall, 3 years old. I have read all the terms of this proposed judgment of divorce, and I agree with them. I ask this court to grant the absolute judgment of divorce. Thank you, Your Honor.
Okay, thank you. I guess I'll ask, ma'am, you have a couple questions for you. Are you currently pregnant?
No,
Have you in fact reside or do you reside in Calhoun County?
yes, Your Honor.
Okay. And did you reside in Calhoun County for at least 10 days at the time that Mr. Hall filed the complaint in this matter?
Yes, Your Honor.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the paperwork in this matter. Sir, have you submitted all of that paperwork to the front of the court yet?
Yes,
Yes, he does. He does have the approval. I sent you the orders, Judge.
Oh, okay, okay.
Yeah.
Didn't know I had the orders yet then. Okay, the court will enter the judgment, the UCSO, et cetera, that's been submitted in this matter. I guess I'd ask Ms. Hall, do you have any questions?
I do. It's mostly, it's not about the divorce, it's about the children. What exactly is that order pertaining to them?
Okay, you'll have to look at the judgment. There's a lot of provisions in the judgment relating to the children. So you'll have to get into the, look at the judgment that he provided you and decide what, I guess, see what he's concluded in that judgment, because that would have all the provisions as it relates to the children.
Okay, and as soon as this is signed, I can go down and change that because I don't care. I'm glad we're divorced. What he's doing to my kids is not okay.
Well, you have a right at any point to file a motion with the court, and a motion is just a request of the court as to whatever you want. You can, doesn't mean you can get it just because you file it, but you can, you can submit it and ask the court for whatever relief you want, but you're going to have to file a motion, then you're going to have to serve the plaintiff at least 9 days prior to the hearing.
Okay.
Okay?
All right. Thank you.
Okay, thank you. Good morning to both of you. This
Good morning.
matter is before the court on the defendant's motion for custody. Ms. Hall, I note you've stated in your motion what you want. However, the court will note that there was a judgment of divorce entered just weeks ago on September 27, 2023, you have to show a factual or legal basis for modifying that judgment since the entry of the judgment. So what is it? What is your basis for modification or changing that custody?
So, Your Honor, back when I accidentally missed a court date because I misplaced the court paperwork. So that's totally my fault. So I wasn't able to like give my side of why I should have our kids.
Okay. Let me tell you how this works. I don't want to cut you off, but you're going to get into a lot. What happens when you are modifying custody? The law states that you can only go back to the date of the last order. So you would have to establish a basis for modification from the September 27, 2023 judgment through the current date. You can't go back and say something happened 6 months ago, a year ago, or whatever, because that order resolved and, if you would, consumed all of those particular issues at that time.
Okay, so I have to, I guess I don't understand. There's no legal reason she can't be with me, so I just don't know what else I can do because she's supposed to be living with me. Dylan and I discussed before we even got divorced that's
Okay.
how we wanted.
Ma'am, none of that matters. The judgment.
I know,
of divorce,
I understand.
okay, so it's from the date of the judgment of divorce forward. What is the basis for modification of that?
Dylan lied on the paperwork and said that she was in school and she wasn't over there. She was enrolled in school over in Battle Creek where I live with me.
Okay.
And he also lied about not having a job, and that's why my child support is so high, and also because he claims that she's in daycare when I honestly don't know if she is or not. Last I knew, she was getting babysat by his sister-in-law because she just had a baby, so they're staying home. So I'm paying $300 a month for childcare that I don't think that she's going to.
Okay. What you can do is you can file a motion for modification of the judgment of divorce, set forth your factual basis. For instance, if it says, if you're supposed to pay childcare and there's no childcare, you can set forth that basis that he's not incurring any childcare and you're being charged childcare. So it'd be anything that would be again, a factual or legal basis for modification of the judgment.
Right. And that's what I don't know. I'm supposed to get proof of that and show you. I don't.
You have to have that, because if you set forth your factual and legal basis, he said, okay, he's not incurring any childcare. Well, his answer to the motion would be, yes, I am, and here's the person. You know, he gets something.
He never showed proof of any of that.
Well, that's because you didn't contest the judgment at that time, and as a result, he doesn't have to if he doesn't establish and provide proof when there's no objection to it.
He's lying about everything now. He's had a job the entire time and he's claiming.
You can always bring that up in your motion to modify child support as well.
I did. Isn't this what I filled out? I'm confused on what I filled out because that's what I went down to a friend of the court and I said, this is what's going on. Can you look into my case? And this is what they handed me for the paperwork that I needed to do.
Okay. Your motion is a motion for custody. Okay.
Okay.
That's what you filed. And so that's what we're addressing. Hold on. Yeah, I'm looking at your motion. I just brought it up. It says motion regarding custody. So that's what's before the court. If you want to address other issues, you'll have to file a motion and provide in your motion that these are the items that you're requesting, the factual basis or legal basis why, and then include what they call an addendum clause, which is your prayer for relief, stating what you want. The only thing I have is a motion for custody. So if you file the appropriate and proper pleadings, and the court will address those at those times, because you have to give the other side notice as to what they're gonna have to defend. And if you file a motion for custody, but then you're talking about parenting time and you're talking about child support and all of that, it doesn't provide them with notice of what you're requesting.
Well, my request is that she comes and lives with me, so that
I
just it'll
understand that.
figure child support
I understand
out.
that, and you've not set forth a basis that the court can look at to make a determination from the September 27th, 2000.
Because I want her to. That's
Well,
why. It
just
shouldn't,
because
she
you
should have
want-
never been taken from me in the first place.
Just
He
because you
took her
want
on
something
false
doesn't-
accusations.
Okay, just because you want something doesn't mean legally the court can do that. Okay?
But-
So what the court is gonna do is I am going to deny your motion because you've not set forth a factual or a legal basis for the court to modify the judgment of divorce at this particular time.
My daughter wants to come live with me. Her dad is
Okay.
keeping both of them from
Okay.
me.
Mr. Hall, is there anything else that you have to add in this particular matter?
Yes, I do. Actually, I've got the proof of her being in
Sir,
childcare.
hold on. I've denied the motion, so you won the motion. So you
Okay.
do you want to argue about winning the motion?
No, if I won,
Okay.
then that's
Okay.
fine.
The rest, if she files another motion addressing all of those other issues she's brought up today, then you have a right to file an answer and again, to refute anything that she states, okay?
Yes, thank you.
Okay, thank you. The court will end this matter at 10:37 a.m. You're free to go. Have a good day. This matter is before the court on the defendant's motion to set aside referee recommendation. And the substance, with all in this matter, you state, and I quote, "With lack of support in the area, it makes me skeptical as to the level of stability our children are going to receive." Is that the basis of your objection?
Yes, Your Honor.
Okay. And that's fine, but when you object to the referee, I cannot set aside a referee recommendation based on speculation as to what may happen. You have to demonstrate that the referee made a factual or legal error. And so what is the factual or legal error that you believe the referee made?
Well, Dylan is now back with his parents with our children. He no longer lives in Ohio.
Okay, and how does that impact the referee's decision?
Because of the fact that my children have been moved from house to house to house in the last couple in the last year, I feel like the stability there is just not there. And I'm worried because of my son's behavior. It's gotten worse over the last year, being floated from here to there. And he needs to be in therapy, and I don't know if he is receiving therapy at this point because he's been bounced around so many times the last year.
Okay, well, if therapy is necessary, you always can file a motion seeking therapy. With that, Mr. Hall, what's your response?
Well, so we actually moved back to my mom's house because I'm actually having a relapse right now. So, and he's in therapy. He sees Jessica every Monday at 7:30. So, we just moved back with my parents so they could help me with my kids, so I could possibly receive the treatment I need.
Okay. Well, in this matter, again, Mr. Hall, why don't you provide Ms. Hall with, again, information as it relates to whoever the child's in therapy with, so she has that information. Provide her with the name, address, and phone number for that particular entity. But what?
I don't have their number.
It's.
Well, find it then, sir. Okay? If you take the child once a week, you should be able to know where they're at, get their card, get their phone number, and provide all of that to her.
It's actually in-home therapy, so I don't take them anywhere, sir.
Well, then you have to have some contact. In-home therapy, do they come into the home? Do they go by Zoom? What do they do?
I've got where the number she texts me off from. They actually come into the home.
Okay, when the person comes in the home the next time, get their contact information and provide that to the defendant.
All right, sir.
Okay? But at this point, the court doesn't have any basis to set aside the referee order. If that should happen in the future, Ms. Hall, you have a right to file a motion to modify the order, and you should do that if in fact you have a basis to do so.
So I do have a quick thing that I'd like to mention. In the referee's paperwork, it only grants me visitation with my daughter. I'm not really sure why that is. It says that I can't see Junior until summer of 2025, and then he's able to come visit every other week. I feel like him and I not being able to see each other has really strained our relationship and has very much affected his mental health.
And ma'am, I don't know why that's in there or what happened, but you'd have to, all I recommend is go back and get a transcript of that hearing. And the referee would normally explain in the transcript what the basis was for his determination, or it would be in his ruling. And then you'd be able to see what that is. But you haven't provided me with anything today that allows me to do the action, take the action that you've requested. So
Sir,
you can file a motion or you can take other action in the future, ma'am.
So his ruling was to get him regulated on his meds and go to therapy throughout this summer so we can get him stable. Then we'll start.
That's fine. I'm just saying based on what I have today, I don't have anything to, again, provide a basis to grant the defendant's relief. So the court will deny the motion at this time. So thank you. You're free to go. Have a good day.
Literally